Hello and welcome to Connected with Latham, where we discuss ideas, legal developments and business trends shaping the global economy. I'm Fiona Maclean, a data and technology lawyer in Latham & Watkins' London office. In this episode, we're going to discuss the EU Data Act, the vast majority of which becomes applicable on the 12th of September 2025. One key aspect of the Data Act, and the subject of today's podcast, is the introduction of significant new service switching requirements on providers of data processing services. I'm joined by my colleagues, Jean-Luc Juhan, a data and technology partner in our Paris office, and Alain Traill, counsel in our London office, to talk more about these new switching requirements, to provide some key takeaways for data processing service providers and their customers, and to consider the broader implications of the changes. Jean-Luc and Alain, welcome to the podcast.
Thanks, Fiona. More than happy to be with you.
Thanks, Fiona. Glad to be here.
So, Jean-Luc, to get us started, can you please provide an overview of these switching provisions that are set out in Chapter 6 of the Data Act? Who do they apply to and how do they work?
Sure. So the EU Data Act introduces significant new switching requirements for data processing services, which are expected, as we say, to take effect on 12 September 2025. These changes are set to radically modify market dynamics, both between service providers and their customers and among competing service providers. So a key aspect of the Data Act is the introduction of these new service switching requirements, which Alain will detail in a minute, on providers of data processing services. The Data Act imposes indeed on such providers to facilitate seamless switching for customers, whether moving to another provider or transitioning to internal on-premise models. For instance, providers are required to eliminate barriers that hinder customers from terminating contracts, porting data and digital assets, and unbundling infrastructure services from other data processing services. These obligations are reinforced by specific contractual terms that need to be specified, allowing customers to initiate switching or porting with a maximum of 2 months' notice and completing the switching process within 30 days unless technically unfeasible. Additionally, providers must identify all data and digital assets that can be migrated, specifying any exceptions, and offer reasonable assistance to facilitate the customer's transition. They also need, as part of their transparency obligations, to provide customers with detailed information on switching procedures and interoperability specifications. There are a lot of questions around these obligations, and the European Commission plans to release non-mandatory standard contractual clauses for data processing service contracts by September 12, 2025, but their practical adoption by major providers remains clearly uncertain.
That's a really great overview, thank you. And what about the scope of the application of the Act? How is that determined?
Right. So I think we can break this down into two parts, the material scope and the territorial scope. First, material scope. So the Data Act's definition of data processing services is quite broad, covering three main categories: infrastructure as a service, platform as a service, and software as a service. These categories encompass infrastructure resources like storage or rented servers, core software platforms for application development and management, and fully provisioned software application hosted by service providers. Additionally, the recitals of the Data Act refer to emerging delivery models such as database as a service, DaaS, as example of in-scope services. So again, there is a very broad conception of what are the data processing services in the text. This broad approach, which finally includes all so-called as-a-service models, is likely to lead to questions of interpretation. Specifically, there may be uncertainty about which services are in scope and whether, for instance, AI services often delivered using an as-a-service model are subject to the Data Act obligations. Also, the service switching provisions do not provide carve-outs for small-scale or emerging providers, nor is there a general limitation to commodity or off-the-shelf services. However, there are specific exceptions, such as services that are heavily customized for specific customers or provided for testing purposes. Now going to the territorial scope. So in line with other EU legislation in the digital and technology field, the Data Act scope is extraterritorial. It applies to providers of data processing services regardless of their place of establishment, as long as they provide services to customers within the EU or place their services on the EU market. This means that several providers based outside the EU will be subject to the Data Act.
Thanks, Jean-Luc. That's a really good framing for these provisions. Alan, turning to you now, can you talk us through the core switching obligations which the Act prescribes? We know the Act talks about removing obstacles to effective switching between data processing services, but what does that really mean?
Thanks, Fiona. Yes, I think starting from what Jean-Luc outlined just a minute ago, that great overview of what follows from that first obligation, as you say, Fiona. One of the key points really is around timing, and I know Jean-Luc emphasized that, but it's worth just looking at that in a bit more detail. So this requirement, again, to initiate a switch on the request of a customer within 2 months, and then to actually implement that switch within 30 days. And this is a great example of where I think the implementation of the Data Act depends very much on context. So for some smaller scale SaaS providers, for example, they may already be well set up to accommodate that request and those timings. That's a relatively common approach on the market. But obviously, if it's a much more in-depth infrastructure or platform service, maybe supporting the core operations of a bank, then those timeframes become quite unrealistic, if we're all honest about it. And in that case, there is an exception. So there's an exception where it's technically unfeasible to meet that 30-day period. And we expect that will come into play. But more generally, I think the dynamic between customers and providers under this act will be interesting. So in that bank scenario, we'd expect more of a conversation and a realistic approach to risk on the part of the bank as well. And it'll be interesting to see how that dynamic works out between the customer and the provider around that timing point. In terms of the other more granular requirements, so there are requirements to provide certain information, so lists of data sets, data types, how they're structured, etc., essentially to enable customers upfront to understand how and when they'll be able to switch and in what way. And that's probably an example of where there'll need to be quite a lot of cooperation within provider organizations. So a lot of leveraging of expertise on the technical and operational front, and then marrying that up together with, what flows through in the contract. There are then some supporting contractual obligations around, for example, facilitating the exit plans of the customers. And that, I think, again, is interesting from a dynamic perspective because, traditionally in many cases, the onus is very much on the customer to make sure it can exit on the right terms and to drive the exit on its terms. Sometimes, very much also driven by the replacement provider if there is one. But this tends to sort of switch the dynamic a little bit and put more of an emphasis or focus on the existing provider to actually support and partially drive an exit. So that'll be interesting to see how that plays out on the market. In terms of the more commercial side to this, so one of the headline changes has been the phasing out of what are commonly framed as egress charges. And these are essentially just charges leveraged on customers sometimes to take their data out at the end of the service. And as I say, those are being phased out. So by 2027, they can no longer be charged. And now we're in a rundown phase. But I think, again, in practice, there are workarounds to this, even for the providers to protect their own commercial positions. So there's nothing in the app, for example, that prevents defined minimum term model, or even a sort of defined minimum commitment model, and then a related payment if the consumption or the term is not aligned with those minimums. So that protects the providers in those cases. And finally, I think it's probably just worth mentioning interoperability and functional equivalence, because those are two things that we end up talking to clients quite a lot about. So on functional equivalence, the headline here is really for infrastructure as a service providers. So that's maybe you're providing sort of core storage, core service as a service. And in that case, there's an obligation to take reasonable measures to ensure functional equivalence for the customer when they transition to the new model. And I know, Fiona, you've been at pains to point out recently that that's often impractical, to say the least, for some providers, given the way they differentiate their service. So a lot of sort of tension around that requirement. And then moving away from infrastructure as a service for SaaS, for example, and platform as a service, is this obligation to make available free interfaces to facilitate switching. And that's probably a good example of where actually there's a bit of commercial opportunity with the Act, because it potentially opens up for providers of those interfaces to go and then onward provide them to lots of entities that are caught by the Act and maybe don't have them up and running at the moment. So yeah, there's a lot to think about in these switching obligations, and that's just a snapshot of a few.
Yeah, certainly. There's definitely a lot to unpack there, Alan. So based on the volume of provisions and things to think about, what should be front of mind for companies trying to assess the practical implications of the Act? What should they be doing next?
Yeah, really, really interesting question. I mean, I guess from the perspective of providers, we'd hope that they look at it not just from the perspective of what they're potentially losing or the obligation side, and also potentially on the opportunity side as well. So that piece we talked about just at the end there in terms of switching interfaces is potentially an opportunity for companies to leverage. And then in a lot of cases, it's maybe an adaptation rather than a sea change to the models. So on the commercial front with the charging, as we talked about, they may not be able to leverage to levy rather egress charges, but they can still protect their commercial position in other ways. On the customer side, it does potentially open up a lot of opportunities. So it's a really good chance for customers to think about, are we in a position here where we want to move to, for example, a parallel run multi-cloud environment? And at the moment, we're not confident that our existing provider will support that. But now this new Act, given these obligations, we're more confident about that. That's an opportunity you can start to explore. So I think that whole strategy piece on the customer side, particularly customers of high volume services, high complexity services caught by this Act, have a lot of opportunity there as well. But those are just some of the themes that come out of the conversations we have.
Thanks. Yeah, there's certainly plenty for companies on both the customer and the service provider side to consider. And of course, we know the Data Act does not exist in a silo as well. So it's within the broader package of EU digital and data legislation and a core instrument in the EU data strategy. So what can we learn from that wider regulatory context, and how does the Data Act and these other laws, how do they all complement each other, and what can companies think about there?
I think maybe I'll share this view to an extent, but they probably complement each other uneasily at best in some cases. But it's interesting to pick on some themes to your question. So I think we all see this theme of increasingly a push to regulate providers of services and not the customers. And again, to take that bank example we talked about earlier on, in the old world or the very recent world, regulation generally in terms of these tech services and their consumption was on financial services regulated entities like banks or other regulated customers. And that's how things flowed through to the providers. But now these obligations are starting to effectively be placed, directly onto the providers. So that's a sea change really in terms of how this regulation all works. And it's a common one to your question, across, for example, DORA and NIS2 as well, and not just the Data Act. So we see that continuation of that theme. And then in terms of their sort of interplay, there are naturally some tensions. So again, if we take DORA as an example, obviously that's all around operational resilience and cyber resilience, etc. So placing quite a big burden on customers and not just providers to effectively make sure that they mitigate or they protect against those risks. Whereas if you combine that with, for example, the timing for switching under the Data Act, which kind of almost gives customers not quite a carte blanche, but along those lines to push providers to switch quickly, you can see that could be quite a risky option. So there's that natural tension for both customers and providers between meeting the sense as well as the sort of specific obligations under all these different acts. More generally, it's obviously, I think we all see this in our work, that it's a real struggle for both customers and providers to get their heads around just the depth of regulation that's coming through at the moment that impacts technology type services. So there's that issue as well. And then obviously, and I know Jean-Luc will be familiar with this from a French angle, the tension between the sort of local laws as well. So in France, for example, there is an implementing law related to the Data Act, and companies will need to factor in that in addition to the base act, and then all the other sort of local implementing laws across the EU as well. So yes, it's a complex picture, and it's it's something that's keeping us all very occupied at the moment.
Thanks, Alan. Jean-Luc, is there anything to add from the French perspective, given the implementing national laws?
Yes, and I think that we could discuss penalties for non-compliance for a minute, because penalties will be set at member state level and are due to be published by 12 September 2025. And as with the EU GDPR, these fines will have to be effective, proportionate, and dissuasive. For example, in France, so the SREN law, which is the Loi visant à sécuriser et à réguler l'espace numérique, which we can translate by law aiming at securing and regulating the digital space, which took effect on 21 May 2024, already incorporated some of the service switching provisions from the Data Act, and includes fines of up to 3% of annual global turnover, increased to 5% for certain repeat breach. So that's interesting to see what could be the level of the penalties. We also know that in Germany, the Draft Implementation Act permits fine up to 4% of the annual global turnover of 5 million, whichever is the higher. So here again, it gives an idea of what will be the sanctions in relation to breaches of the Data Act.
Thanks. That's super helpful to understand. But maybe we can end on a slightly more positive note than sanctions and enforcement. Alan, you've certainly mentioned some of the commercial advantages that are opened up and the opportunities that exist as a result of the Data Act. So it would be helpful to hear just from both of you, actually, about what can companies do to get ahead of the game, and how can they take advantage of the changes that are introduced under this new law?
I think there are obviously challenges and opportunities. Just to mention one challenge at the beginning, but I see one for the providers, which is to first determine how the Data Act applies to their existing services, especially complex offerings like hybrid cloud and on-prem solutions. But in terms of opportunities and for the providers, there is one which could be obvious, which is that providers will also be in a position to attract more easily new customers moving from one provider to the other, thanks to this that new Data Act regulation. But that will be subject, of course, for the providers to develop adequate commercial strategies to attract new customers. On the customer side, I see some significant opportunities for them to recalibrate their IT and digital solutions. With greater contractual and practical freedom, customers will be in a position to explore multi-service environments for enhanced resilience. And this is a great moment for them to revisit their IT procurement strategies.
Thanks, Jean-Luc. Yeah, I mean, I'd echo all of those points. I think really interesting insights. And in terms of what I can add, I mean, I just maybe emphasize that some providers feel they're in a really good position with this app because they feel like, particularly providers that have grown up over the past decade or so, they feel like they've designed their service in many ways to accommodate this kind of approach, to be very open to sort of multi-cloud environments, very pro-switching, and as you say, Jean-Luc, to be in a position to really allow customers to transition in and out quite effectively as well. So in many cases, they feel like they're well prepped for this act, and this actually probably helps them because it moves things more in that direction. But yeah, we also appreciate there's the other side as well, and there's quite a bit of work in some cases for providers in particular to sort of walk through their terms, walk through their operational, practical processes in terms of data segregation and so on, just to make sure that they're ticking the boxes of compliance. So that's what we're helping a lot of clients with at the moment. And it'll be really interesting to see how this changes things and how it changes the market dynamics.
Yeah, we'll certainly be monitoring that very closely. So thank you both, Jean-Luc and Alan, for this really interesting discussion today. I think also with the Act applying on the 12th of September, hopefully this discussion has been very timely for our listeners to consider how their businesses may be impacted. And it's also offered a few thoughts on steps that they may need to take to prepare. So thank you very much for your time.
Thank you for having me today.
No, thanks very much. It's been a pleasure.
And thank you all for listening to this episode in our Connected with Latham podcast series. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Spotify, or wherever you get your podcasts. If you'd like more information about the topics in this podcast, please email us from links located in the show description. We hope you'll join us again next time.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.